What is standard of care and why it's important to you as a medical professional? And more importantly, how you can stay within your standard of care and make sure that you're not subject to any unwarranted liability. So amongst physicians or lay people, usually they talk about malpractice being any unskilled or bad or negligent treatment that causes or injures the patient. Now that can be an action that you take or an omission that you do not take in your care of that patient. So how do we determine if your actions or omissions are bad, unskilled, or negligent? Well, we come up with standard of care. And before we get to that definition, we have to kind of go backwards and say, to win a lawsuit, what does a plaintiff have to prove in order to win? So in most states, the plaintiff has to establish that the professional owed a standard of care or a duty of care to that patient. For example, if you've chosen to treat that patient, then you now have a duty to treat that patient well without being negligent or unskilled. There are cases where you don't have a duty to the patient, such as when somebody's really far away and someone says, help. I mean, human beings have an instinct to go help, but in certain situations, you don't necessarily have that duty out of nowhere. You can choose to see the patients that you'd like to see, unless your situation calls for you to be on duty, let's say at an ED or an emergency room. Then, of course, you have a duty to treat those patients that come into the ED. But ordinarily, there is not a duty to treat somebody unless you've chosen to say yes to that duty. That's generalization, and that goes really far back. But let's move on. So they need to establish a duty of care that you as a professional have breached that duty, acting negligently or unskilled in an unskilled way, and that your breach, the way you acted, was a direct and legal language alert proximate cause of the patient's damages. So it was either direct or it led to the injury maybe a couple of steps later. So we're talking today about standard of care, and lawyers use more in a negligence standpoint, we use duty of care. So the duty of care is similar. It just refers to the medical professional's obligation to follow the appropriate standard of care. So they're kind of synonymous for the lay people and for the professionals out there. You can think of the duty that you owe to that patient is to follow the standard of care. But what is standard of care? A quick anecdote, a lot of my members in the functional lawyer membership, and even my wife, who is a functional medicine doctor, a DO, have experienced something like this. A patient comes to them at functional medicine office and they propose a plan of treatment. The patient is informed. They have an informed consent dialogue. They document it with a written informed consent form. But then the next time that patient goes to their primary care provider, the primary care provider, who doesn't have the same education, training, and experience as the functional doc, says, well, why would they propose that plan of treatment? That's not standard of care, right? And to them, it isn't standard of care because the definition of standard of care is generally the degree of care that an ordinarily prudent medical professional practicing in the same area of medicine would have used in the same situation. So arguably in that example, a PCP and someone that's board certified in family medicine are in the same area of medicine. However, that definition doesn't take into account the education, training, and experience of the two doctors. One who presumably has been raised and trained conventionally doesn't have the same tools in their toolkit to treat somebody functionally. They don't have the same knowledge, education, or experience in treating functional medicine in that kind of mindset. So we'll get to another definition in a minute, but just let's talk about a little bit more about what standard of care is and how we determine the same education, training, and experience. As America was growing and as transportation was getting faster, obviously the standard of care that you would receive at a hospital in Boston or New York in the 1800s or let's say even the early 1900s, would be much greater than your town doctor in Montana or South Dakota, the Black Hills area during the gold rushes out there, because the doctors in Boston and New York have access to a lot more information, both from the East Coast of the United States and from people coming back and forth from Europe. They would have access to a lot more tools and more breakthrough medical discoveries and new processes, so that a doctor in either rural America or way out west back in about 100 years ago would definitely not be held to the same standard of care. So that led to what's called the locality rule. And you'll still see this if you Google standard of care or medical malpractice locality rule. And so the standard of care used to be a doctor should do the same, have the same treatment and as other doctors with the same area of medicine in their locality. So it was actually designed to help doctors that were rural. They didn't expose them to excess liability, because there's no way they could have the same information and training as somebody in a metropolitan area in the early part of the last century. But as the country has grown and transportation and communication have both taken off, no pun intended, the locality rule has been a little bit replaced by a kind of a uniform national rule. And so most states now define the standard of care as the degree of skill and learning ordinarily possessed and used by other members of the profession. Now that is to say, within your same specialty. So specialists within the field are generally held to standards of care that are higher than those for general practitioners. And specialists will be compared to other specialists in their field. So for our purposes, we can kind of say functional medicine is its own specialty these days, or at least that's what we will propose. And so you can take comfort in the fact that your education, training, and experience now is part of a growing, still minority of doctors and other healthcare practitioners, kind of doing the same thing that are ordinarily done to the level of performance applied to functional medicine as a specialty, even if you're not certified as a specialist in that field. So that's where we need to talk about what's called the respectable minority rule. And so within functional medicine, you would be compared to other functional medicine providers. So not PCPs that are conventionally trained and have no additional knowledge of functional medicine. So that you can take some solace in that fact that so long as you're being prudent within your functional medicine training and experience and education, then you will be following your standard of care. Now, that doesn't help you if there's any kind of actions against you or lawsuits. And so what's going to come into play here soon is the respectable minority rule. So I said functional medicine is growing, and there's a lot more than there were even 5 years ago, and definitely 10 and 20 years ago. And functional medicine is just a term. It's not really a certification. There's no board certifications yet nationally that are recognized by states, although that should be changing soon. So in today's world, we would kind of fall into the respectable minority. Now, what that means is, before this doctrine came about, doctors that were doing things that were a little bit more cutting edge or a little newer, and still helpful, still good, and still backed by evidence and science, but they were kind of going out on a limb, really, because they're being compared to their peers that are trained in the same way, but have no idea what that method or protocol is. So now a lot of states have what's called the respectable minority rule, which means even if you deviate from mainstream medicine or what the majority of physicians in your specialty would do, but if you choose to follow a technique that's used only by a small number of respected practitioners, you would be exempted from liability so long as you followed that kind of standard as well. So it can be difficult for a court or judge, and court and judge are synonymous for attorneys, it can be difficult for a court to determine what is a respectable minority for a particular technique or process or protocol. But if you get some good expert witnesses, expert testimony that backs you up from other functionally trained docs, hopefully they're certified and they have a lot of certifications after their name. Jurors like to see that. But you can take solace in the fact that, one, you're going to be compared as your standard of care to other people doing the same thing as you with similar education, training, and experience. So long as you kind of follow that standard, you ought to be good as far as following standard of care. And there's another safe harbor for you if you can show that a respectable minority of doctors are doing the same thing and with the same caution and prudence and care for patients, then you would also likely fall into a respectable minority exemption or safe harbor for the things that you're doing. Now, it's very important to note that as you're building your practice and money isn't exactly overflowing your cup, it can be tempting to take on patients where your skills are not at the level required. So, for example, if you hang your shingle, you open your practice and you are really just doing functional medicine and whoever comes, you're going to accept them, right? You need to know the line at which your education, training, and experience is crossed. Because if you start to feel uncomfortable, you should probably trust your gut, because that's where people get in trouble, where they start something new that they don't have a lot of experience in. And then, a patient ends up getting hurt. And then they say, well, how much training did you have on this machine or for these hormones or for this laser? And you can't point to a lot of training, or you are doing something that's experimental and you didn't get an informed consent from the patient, then it starts to be an issue. So be careful and know your own limitations. So your education, training, and experience is what matters. If you're not trained up on the Bredesen protocol, if you're not trained up on the Walsh protocol or anything else, maybe don't take on those patients. So if your bread and butter is people that are generally autoimmune, be careful trying to take on people that are a little bit more special, like mold patients, Lyme patients, toxicity patients, metal toxicities. Point is, be careful when you go out on a limb and stay within your education, training, and experience. And if you do so prudently, you ought to be okay and insulated from any kind of negligence or malpractice actions against you. Now, any professional in any profession that requires a license, if they practice long enough, will have some dissatisfied person that may lead to some sort of a claim against them. You practice law long enough, you'll get one. You practice medicine long enough, many of you maybe have already had them. But you can take solace in the fact that if you stay within a reasonable education, training, and experience that you have, and it's taught by respected institutions or training programs, then you'll be safe in following the standard of care. So the standard of care, once more, is comparing yourself to peers in your specialty that are undertaking to perform procedures that are applied to the level of performance to other specialists in that field. So again, if there's a group of you and you deviate from that group, it may be a little bit of an issue, but if you're being reasonably prudent, you're taking all the right precautions and prudent steps and researching and backing it up by kind of some judgment, you will be safe in following the standard of care. There is another doctrine that you should be aware of as well, and that is that for a reasonably prudent doctor who has a choice between two paths to make a decision, should not be held liable if they chose one path and it didn't work out, if that is more of a judgment call, part of the art of doctoring or being a health professional, and less of the science where, okay, well, let's try this method and let's see how that goes. And then if we have to pivot later on, we can pivot there. So long as that choice is one that a reasonably prudent doctor would make in using their professional judgment, there's another safe harbor there for you. So to recap, don't be afraid if somebody who's conventionally trained is saying that's not standard of care, or your patients explain to you that their PCP said that your treatments were not standard of care. If you've backed it up with your education, training, and experience, you can explain to the patient that, yes, of course, standard of care is not the same for me and your PCP who doesn't have the same training. And with that, I hope you all sleep better tonight, and we'll see you guys next time.